The ANC is unrelenting in its fight against the MK party as it approaches the Durban High Court to claim the logo and the name as its intellectual property. The governing party suffered a fresh loss in the Electoral Court, where it sought to have the political newcomers deregistered by the IEC. Our reporter Ziyanda Ngcobo is closely following the story and now joins us live from Durban. Ziyanda, I have to say that you have possibly the hardest working reporter. Just yesterday you were in Johannesburg and now you're in Durban, and again it is the ANC versus the Ngcobo political party.
Yes, Aljan, so sweet. Thank you. But it's because it's such an important moment in the run-up to our elections, an indication of the continued fallout of, internal political management, or the lack thereof within the ANC. Because for all intents and purposes, the Ngcobo party is a faction of the ANC. And so this is why then we have to keep track of these issues. Certainly a more complex court hearing today. Oral evidence will be given. A full bench will hear this matter, where they'll be dealing specifically with the Trademark Act. And let's bring in the legal expert, Mpumelelo Zigalala, who knows better than I do, because basically the ANC is mounting its argument on the basis of Section 34 of the Trademark Act. Let's talk about the basic argument that they're making, and then let's also unpack what the law says around issues of intellectual property.
Good morning to you and also to your viewers. Basically, it's two things. They're saying the Ngcobo brand belongs to us. The goodwill associated with Ngcobo also belongs to us. Any person that wants to utilize this must come and look for permission pertaining to the ANC. Two defenses in which they are mounting with the attacks. The first one, they're saying, due to common law principles, whether it's registered or not, it belongs to the ANC and nobody else. And also in the Trademark Act, there is a brand or a logo that has been registered detailing what the Ngcobo is actually stating. So on those bases, they are saying any infringement that takes place, it must be protected, and that is basically what they are doing. On the Ngcobo side, by the way, they are coming back and saying, firstly, there's a situation called that we call a nine-joiner. The person or the entity that is registered to Ngcobo is not on the court papers, and yet they're interested parties. You did not join them, so on that basis, your application should fall apart. Again, the SACP is also brought into the fore, and they're also put on. They're not on the court papers. But most importantly, they are saying you come to this court on an urgent basis. When your matter is not urgent, we are looking for a final interdict. You provided us enough time to order to detail our defense. On that basis, or due to your matter not being urgent, then we urge the court to dismiss this application altogether. But most importantly, this name Ngcobo and also the logo does not belong to you as the ANC.
In fact, that's where I wanted to go, because it would seem that the history of the movement, and in particular the alliance, will be in question here today, because in the Ngcobo papers, MK Party's papers I should say, they are saying Ngcobo was founded by the alliance, which the ANC is a part of, but it doesn't belong to the ANC. How much of an impact will such an argument have when the ANC is saying, well, but we registered this as our intellectual property 10 years ago? How technical are these arguments going to be?
It's going to depend on the papers and the evidence that is there. If you say you've registered it 10 years ago, show us that proof, then you are going to be happy. However, if it is registered by the Legacy Project, an entity which is not on the court papers, an entity which did not say we want to protect our infringement, hence we are going to court, then that application falls to fail, because the person that should be defending the infringement is not there. If you say you've been utilizing that particular piece of information, it does not necessarily mean that because you've been stating it in your slogans, putting it in your papers, putting it in your conference, it does not mean that that particular name or the brand belongs to you.
And how much of a prejudice would the ANC face if then the court rules in favor of the Ngcobo party, insofar as the argument that the governing party has made about the confusion that this could cause, and that the former president has stolen what belongs to the heritage, because heritage and intellectual property aren't necessarily the same thing. So the ANC is saying this is part of their legacy and heritage. So on the issue of prejudice, are you able to assess how bad this could be?
Well, I think for now, the only thing which they're going to focus on is going to say, you have the potential of confusing the voters or our core voting line or numbers that are going to vote for MK, thinking that it's part and parcel of the ANC when exactly it is not. If that's the basis of the argument, then it tends to be flawed a bit, because what you are contesting against and what the Trademark Act and also the common law principles seek to protect is predominantly the financial gain or the goodwill of the name of that particular individual. Now, goodwill and economic gain goes hand in hand. So if you're not going to exercise any or show any economic gain or loss that you're going to suffer, then your application can fall in a certain point of view. The MK can then come back and say, but you know, when we are campaigning, which is clear that this is not the ANC, when we are campaigning and it appears on the ballot box, is completely different identities and brands, which is the ANC and also the MK, so it is easily identifiable for any person who is a voter. So there's no loss which is going to take place. It is simply going to be the people of South Africa dictating or choosing which individuals they want to vote for. So whether you get this application or not, at the end of the day, there's no loss in which you are going to suffer, which I think, again, is something that they're going to hinge on in terms of the protection of that legacy. But one of the important points being that who is the actual owner of the brand, who is the actual owner of the name, and also the logo.
Mpumelelo Zikalala is a legal expert. He'll be spending the day here with us, Aldrin. And it's important to note that no cameras or videos are allowed inside the courtroom. So I'll be entering this court as a scribe. And this has been a decision that came straight from the office of the Chief Justice, Aldrin. So no live proceedings will be coming from us today. But equally important, former President Jacob Zuma will be in court here today. I've already seen members of a security detail, sweeping the area, and the Umkhonto weSizwe party from this hour are expected to start gathering for a peaceful picket outside this court.
Well, Ziyanda and Ngcobo, they're joining us from KwaZulu-Natal, where that matter will be heard a bit later on. Unfortunately, as she did indicate, that there will be no live proceedings that will be carried because of the decision that has been taken by the court.